Hi, good afternoon, everyone. Welcome to this afternoon's session. It's our second session of JAI Week 2024, and it is my esteemed honor to welcome His Honor, Mr. Sunil Sookraj. Mr. Sookraj, His Honor Sookraj, sorry, is the former chairman of the Environmental Commission of Trinidad and Tobago. He has a very engaging presentation for us planned this afternoon on environmental issues. His full bio has been shared with you in the chat, and it's included in the program. So as to not detract from his presentation, I'll now hand this over to His Honor Sookraj. Your Honor.
Yes. Thank you very much, Mr. Emmanuel. Are you hearing me?
Yes, I can hear you.
Yes. Okay, great. So good afternoon, everyone. And let me begin by adopting all the protocols already established. Now, it is my esteemed honor and privilege to have been invited to make this presentation to you this afternoon. Before commencing, I wish to take a moment to extend the commendations to the Chief Justice of the Turks and Caicos Islands and her entire team, including the Judicial Education Institute of the Turks and Caicos, of which the Honorable Chief Justice is the chairperson, for organizing this very important week of activities, Judicial Education Week. Education helps us to achieve certification, but more importantly, it equips us with the technical knowledge and ability to perform a task, critically analyze situations, and make informed decisions for the betterment of humanity. And in our case, that is within our area of influence as judges and judiciaries. Continuing education in today's world is also critically important if we are to keep up with developments taking place around us. For this reason, events like this week's activities are so very important, not only in shaping the minds of our younger members, but also for continuous lifelong learning as more experienced members of courts and judiciaries, especially if we are to remain current. I've been given a very broad topic to share some thoughts with you on today, and that topic is environmental issues. Not so long ago, many did not think of the environment as something that was important to us and even took it for granted, thinking that it will always be here to support our behaviors and lifestyles. In just a few years, over a short period of time, the conversation has now changed to refer to a safe and healthy environment as a fundamental right or as a human right. For many of us in the legal profession as well, when we spoke in the past of environmental matters, we were more concerned with common law causes of actions and nuisance, negligence, and the rules in Rylands and Fletcher. While these are very important and relevant even today, there has been the development of a whole new area revolving around climate change and climate litigation and related matters. We are all very aware of the challenge that confronts us as the world struggles to keep a check on the rise of global temperatures by reducing anthropogenic greenhouse gas emissions into the atmosphere. While this struggle continues, all of Earth's inhabitants are already being called upon to adapt to climate change, some more than others, like us in the Caribbean region. I think that we can all agree that because of the size of our islands, the effects of climate change are significant for us, not only in terms of flooding and increasing temperatures, but also the effects of these on the spread of related diseases, on agriculture and economic impacts. We in the Caribbean face very many challenges from climate change. As we are all aware, the vast majority of our nations are islands, and we fall under the category known as SIDS, or small island developing states, which makes us, or which points to our vulnerability. Recognizing this is certainly important, but of course, doing something about it is even more important. A very important step for us in the Caribbean is that of capacity building when it comes to climate litigation and the overall strengthening of environmental justice in our region. Judiciaries and judges are not omitted from having a key role to play in this regard. It is important, therefore, for judiciaries to be cognizant of this fact and to ensure that matters impacting the environment or the environment in general be given greater judicial consideration. let us not underestimate the work that judges do. Judges have the power to effect change through their decisions and through their application of the law to the facts before them. So I move now right into the presentation, environmental issues. So, Mr. Emmanuel, if you can go to slide 2.
Yes, certainly, Your Honor.
The second slide. Yep, environmental issues. In addressing and dealing with matters that impact the environment, which I shall refer to as environmental matters for ease of reference, regard must be given to the following factors, which are in no way intended to be exhaustive. So let me say that up front. And they are: 1, constitutional protection through provisions contained in a nation's constitution; 2, standing; 3, treatment of and awarding of costs; and 4, international law. I will address each of these individually. So the first being constitutional protection. Next slide, Mr. Emmanuel. Now, courts, and more specifically judges, have to ensure that they are careful to give necessary regard to protections afforded to the environment for its protection and safeguard. Now, in the case of Gaskin against the Minister of Natural Resources and others, a case from the Caribbean Court of Justice, and it is CCJ appeal number 005 of 2023. It's a case from Guyana. Justice Anderson made the point that the environment was being placed upon an exalted plane in the juridical consciousness of the citizens of Guyana. He stated at paragraph 43, and I quote, "The Constitution of Guyana is the supreme law of the land. In expressly providing for environmental rights, the Constitution invests in the protection and preservation of the environment with high constitutional values. The protection of the environment is thereby placed upon an exalted plane in the juridical consciousness of the citizens of Guyana. The constitutional importance attached to environmental preservation must necessarily be borne in mind when interpreting legislation that touches and concerns the environment and forms a proper background against which such legislation must be interpreted and applied." End of quote. In his judgment, Justice Anderson acknowledges at paragraph 44 that although the case is not related to environmental protection provided in the Constitution of Guyana, and I quote here, he says, "It is important that Article 149J, and that's 149J of the Constitution of Guyana, contemplates that the state's environmental responsibilities will be given effect through reasonable legislative and other measures." End of quote. Then, sorry, and I continue quoting. "The Environmental Protection Act and regulations are primary among the reasonable legislative and other measures contemplated by the Constitution, and their interpretation and application form the core of this case. End of quote. Article 149J of the Constitution of the Republic of Guyana is one that I'll refer to now, and I'll read the article in its entirety. 149J1 provides that everyone has the right to an environment that is not harmful to his or her wealth or well-being. 2, the state shall protect the environment for the benefit of present and the future generations through reasonable legislative and other measures designed to: A, prevent pollution and ecological degradation; B, promote conservation; and C, secure sustainable development and use of natural resources while promoting justifiable economic and social development." Justice Anderson noted at paragraph 53 in the Gaskin case that, and I quote, "Construction of the Environmental Protection Act as a whole ensures that the specific provisions that the court is asked to interpret and apply are placed within their proper context, including their constitutional moorings." End of quote. He went further to state that the environment, and I quote, "The Environmental Protection Act must be construed as a whole and within the context of its objectives, including its constitutional underpinnings. Thus construed, the Environmental Protection Act describes a role for the developer which goes considerably beyond the mere applicant or the mere application for an environmental authorization for a project. End of quotes. Next slide, Mr. Emmanuel. Yeah. Courts, in my view, have to be cognizant of the importance of allowing parties who come before it in environmental matters the opportunity to fully ventilate their cases. While you may argue while courts may argue that it always does so, it has to be careful to not fall into error of treating environmental matters like any other matter. Environmental matters do require careful thought and handling, and the need for courts to be sensitive to the potential harm that can result from an error of judgment on its part, or from the undue or not allowing a matter to proceed. As President Saunders stated in the Gaskin case at paragraphs 121 to 123, and I quote, Mr. Gaskin's grave fears alluded to are not to be derided or brushed aside. They are risks that naturally attend subsea drilling. Corporations, government agencies like the Environmental Protection Agency and other public entities have a solemn obligation to hold themselves accountable for the steps they take in the management, conservation, protection, and improvement of the environment. There must be scrupulous compliance with relevant statutes and regulations. Good governance, fairness, and utmost transparency must be observed. In this regard, information about policies and decisions, applications and applicants must be readily made available to the public. Transparency promotes trust and facilitates public participation in environmental decision-making processes. When information about environmental policies, regulations, applications for permits, and enforcement action is readily available, it becomes easier for the public to identify instances of non-compliance or misconduct, and for the Environmental Protection Agency and other bodies to take appropriate corrective action. End of quote. Courts therefore have the responsibility to be fearless when applying the law in environmental matters. Now, the concept of intergenerational equity, and Mr. Emmanuel, if we can go to the next slide. The concept of intergenerational equity is included in the Constitution of Guyana. Article 149J2 of the Constitution of Guyana provides, although not explicitly referring to it by name, has done so in substance by the language used, and I quote, protect the environment for the benefit of the present and future generations. Now, this is a concept that judges today need to be very familiar with and comfortable with as well, if courts are going to do its part to ensure protection of the environment for present and future generations. The principle of intergenerational equity states that every generation holds the earth in common with members of the present generation and with other generations, past and future. The principle articulates a concept of fairness among generations in the use and conservation of the environment and its natural resources. In 2018, in the case of Barragan et al. Against Presidencia de la República, the Colombian Supreme Court was faced with a complaint alleging the violation of a wide array of fundamental rights through the rapid deforestation of the Amazon rainforest. The young plaintiffs demanded, among others, an intergenerational agreement to reduce the said deforestation and counteract one of the main drivers of global climate change. In what has been called a highly heterodox landmark decision, which placed intergenerational solidarity at the heart of its argument, the justices sided with the plaintiffs. In another unusual move for the Colombian judiciary, the court drew heavily on international environmental law and on the Paris Agreement in what must be interpreted as a progressive deepening of the dynamic relationship between international norms and national judicial practice. A similar conclusion was reached some months later by the Supreme Court of Nepal in the case of Shrestha versus the Office of the Prime Minister et al., and the citations are on the slide, in which an environmental lawyer, Ms. Shrestha, successfully petitioned the court to compel the Nepali government to enact comprehensive climate legislation in line with its international legal obligations. The court also followed the petitioner's reasoning that such a law should center climate justice concerns for current and future generations in accordance with the principle of intergenerational equity. Importantly, and to note, the government swiftly implemented the decision by adopting the Environmental Protection Act of 2019 and the Forest Act of 2019 as well. The Shrestha case demonstrates the power of the courts to impact the actions of government, a tool that consideration should be given to using more often. Now, in the New South Wales case, emanating from the Land and Environment Court's decision in Gloucester Resources Limited versus the Minister of Planning, which has also attracted extensive commentary. The petitioner, Gloucester Resources Limited, challenged the public authority's denial to grant its application to construct a new coal mine in an ecologically pristine region of New South Wales, a decision ultimately upheld by the court. In a detailed judgment, Justice Preston weighed the project's costs and benefit in light of both domestic laws and international obligations. His analysis also paid attention to distributive implications of approving the mine, including those for future generations. And he said, and I quote, at paragraph 415, the economic and social benefits of the project will last only for the life of the project, which he deemed to be less than 2 decades. But the environmental, social, and economic burdens of the project will endure not only for the life of the project, but some will continue for long after. The visual impact of the project, even after mining rehabilitation, will continue. The natural scenery and landscape will be altered forever, replaced by an artificial topography and landscape. Now, in another case, in the case of DG Khan Cement Company Limited against the government of Punjab, a constitutional petition challenging the Punjab government's decision to bar the construction or expansion of cement plants in an environmentally fragile area was filed. The Supreme Court of Pakistan took the opportunity to not only quash the complaint, it also expanded proprio motu and at length on the overriding importance of safeguarding environmental resources for future generations. It stated at paragraph 19 that another important dimension of climate change is intergenerational justice and the need for climate democracy. The tragedy is that tomorrow's generations aren't here to challenge the pillaging of their inheritance. The great silent majority of future generations is rendered powerless and needs a voice. This court should be mindful that its decisions also adjudicate upon the rights of future generations of this country. It is important to question ourselves, how will the future generations look back on us and what legacy we leave for them? This court and the court around the globe, this court and the courts around the globe have a role to play in reducing the effects of climate change for our generation and for the generations to come. Through our pen and jurisprudential fiat, we need to decolonize our future generations from the wrath of climate change by upholding climate justice at all times. Yes, if we can move to the next slide. Yes, thanks. The next point I move to now is standing, the second point that I highlighted early on. In treating with matters affecting the environment, courts are very likely to be confronted with the issue of the standing of the plaintiff or claimant and must resist being overly restrictive in its approach, as to do so could prevent the matter being brought before the court, and that in turn might disable the court from performing its function to preserve the rule of law. Now, EcoSuds and others versus the Minister of Environment, Solid Waste and Climate Change and another. The Privy Council is a Privy Council Appeal number 70 of 2023. The Privy Council at paragraph 87 stated, and I quote, "The board considers that absurdity results if prejudice is confined to economic prejudice and prejudice to a private interest. The absurdity can be demonstrated by the example of a proposed development in the center of a vast, remote, idyllic wilderness, all of which is in the ownership of the developer. The more remote the area and larger its size, then the less likely it is that there will be a person with an economic or private interest which has been unduly prejudiced by the minister's decision to approve the issue of an EIA license. The absurdity can also be demonstrated by the converse example of a proposed development in an area which has already been built up. In a built-up area, the environment may already have been adversely affected, but it is more likely that a person's economic or private interests will be prejudiced. Accordingly, the outcome of these examples is that the safeguard of an appeal process would be denied in relation to the remote idyllic wilderness in which a pristine environment may well call out for protection, whilst the safeguard of an appeal process would be available in a built-up area where the environment may already have been adversely affected." End of quote. Now, the court went on to state at paragraph 18, and I quote again, that the board considers the example of the remote idyllic wilderness does not just demonstrate the absurdity of confining prejudice to economic prejudice and prejudice to a private interest. It also demonstrates that the purpose of the Environmental Protection Act 2002, which was the act in question there. So it also demonstrates that the purpose of the EPA 2002 of protecting the environment would be circumvented. The legislative purpose in introducing requirements as to standing is to be understood within the larger purpose of the EPA 2002, which is the protection of the environment. If prejudice were to be confined to economic prejudice or prejudice to a private interest, then in the example of a remote idyllic wilderness, there would be no one allowed to speak up on its behalf in an appeal to the tribunal. Furthermore, the tribunal would be powerless to protect the environment. The larger purpose of the EPA 2002 would be thwarted. End of quote. At paragraph 89, the board agreed that a test of property rights or economic interest is not appropriate in an environmental context when considering standing under section 54.2b of the EPA 2002. The board rejected the submission that prejudice in that section, the section 54.2b, is confined to economic prejudice and prejudice to a private interest. In answering the question as to what prejudice must be shown in an environmental context, the court stated that the answer is that prejudice in the sense of harm can be to an interest in the environment as well as being prejudiced to an economic interest or to a private interest. Now, further in the case of Mussington and another versus the Development Control Authority and others, Privy Council case 116 of 2021, the issue of standing was also addressed. In the Mussington case, the Privy Council made reference to the cases of AXA General Insurance Limited against HM Advocate and the case of Walton versus Scottish Ministers. In the case of AXA, the court departed from the restrictive approach to invoking the supervisory jurisdiction of the court. Having explained that a rights-based approach to standing was incompatible with the performance of the court's function of preserving the rule of law, Lord Reed stated at paragraph 170, and I quote, "For these reasons, I have explained, such an approach cannot be based upon the concept of rights and must instead be based upon the concept of interests. A requirement that the applicant demonstrate an interest in the matter complained of will not, however, operate satisfactorily if it is applied in the same way in all contexts. In some contexts, it is appropriate to require an applicant for judicial review to demonstrate that he has a particular interest in the matter complained of, the type of interest which is relevant and therefore required in order to have standing will depend upon the particular context. In other situations, such as where the excess or misuse of power affects the public generally, insistence upon a particular interest could prevent the matter being brought before the court, and that in turn might disable the court from performing its function to protect the rule of law. I say might because the protection of the rule of law does not require that every allegation of unlawful conduct by a public authority must be examined by the court, any more than it requires that every allegation of criminal conduct must be prosecuted. Even in a context of that kind, there must be considerations which lead the court to treat the applicant as having an interest which is sufficient to justify his bringing the application before the court." End of quote. Now, in the Walton case, Lord Hope of Craighead considered the question of standing in the context of environmental law. And at paragraph 152 of the judgment, he stated as follows, and I quote, "An individual may be personally affected in his private interests by the environmental issues to which an application for planning permission may give rise. Noise and disturbance to the visual amenity of his property are some obvious examples, but some environmental issues that can properly be raised by an individual are not of that character. Take, for example, the risk that a route used by an osprey as it moves to and from a favorite fishing lock will be impeded by the proposed erection across it of a cluster of wind turbines. Does the fact that this proposal cannot reasonably be said to affect any individual's property rights or interests mean that it is not open to an individual to challenge the proposed development on this ground? That would seem to be contrary to the purpose of environmental law, which proceeds on the basis that the quality of the natural environment is of legitimate concern to everyone. The osprey has no means of taking that step on its own behalf, any more than any other wild creature. If its interests are to be protected, someone has to be allowed to speak up on its behalf." End of quote. Applying this guidance in the Mussington case, the Privy Council noted that the Court of Appeal erred in taking too narrow an approach to the issue of standing. In particular, the Privy Council found that the Court of Appeal was wrong to dismiss the case of Walton as having no relevance to the proper interpretation of the civil proceedings rules in that case. In Mussington case, the Privy Council went on to state at paragraphs 49 to 50 that, and I quote, "Barbuda," and this is a case from Antigua and Barbuda, "Barbuda is a small island. Both the appellants live in the village of Codrington, about 2 kilometers from the airport and not far from the end of the runway. The airport will result in air traffic with attendant noise, general disruption, and environmental damage. An issue of concern arising from the Brosnan report was in respect of hydrogeology. It was noted that a resistivity study was required to be conducted to identify aquifers on or in close proximity to the site that might be adversely affected by the operation of the runway. This was important in identifying the impact of runoff from the airstrip on Barbuda's aquifers, which are used for the extraction of potable water. The possibility that drinking water might be affected by the airstrip's operation might be of serious concern to residents of Barbuda. The issue of hydrogeology was an issue raised by Mr. Mussington from his visit to the site in November 2017, end of quote. The potential noise and disruption that will flow from the operation of the airport, and I quote again, in close proximity to the appellants, together with possible concern over the quality of drinking water as a result of the airstrip's operation, clearly demonstrate that the appellants are substantially affected. And the Privy Council further stated at paragraph 57, and I quote, where an application for judicial review involves issues of environmental concern, it is not necessary that the applicant demonstrates an expertise in the subject matter. All that is required is that they demonstrate some knowledge or concern for the subject. So an amateur ornithologist or bird watcher might raise a concern about the potential loss of a bird's habitat, or a fisherman about the effect of a hydroelectric scheme on fish, or a local historian about the effect on an archaeological or historical site, or a local resident on the loss of a local beauty spot frequented by local community. In Walton, Lord Hope in effect asked the rhetorical question, who speaks for the Ospreys? The answer is, whoever can demonstrate a genuine interest in their faith, end of quote. The Privy Council found that the appellants in the Mussington case had demonstrated sufficient interest in environmental issues and the breaches of the 2003 Act raised by the applicant for the development permit. So the Privy Council found, that the appellants had demonstrated sufficient interest in the environmental issues and the breaches of the 2003 Act. And at paragraph 58 stated, and I quote, in particular, Mr. Mussington's scientific background, his knowledge of the flora and fauna in the area, his status as a local resident, and his experience of conducting environmental assessments amply demonstrate a sufficient interest in the subject matter. The Privy Council stated at paragraph 59 of his judgment, and I quote, such an approach is consistent with Antigua and Barbuda's obligation on the international plane under the Regional Agreement on Access to Information, Public Participation, and Justice in Environmental Matters in Latin America and the Caribbean, known as the Escazú Agreement. The Privy Council noted that Antigua and Barbuda was the first country to sign the agreement on the 27th of September 2018 and ratified it on the 4th of March 2020. Amongst other important provisions, Article 7 of the Escazú Agreement provides for public participation in the environmental decision-making process. Next slide, Mr. Emmanuel. Now, treatment of an award of costs. Courts have to be aware that in many instances, parties approaching the courts for relief in environmental matters do so at great risk and peril to themselves, and in many instances do so through the generosity of others, as they are not themselves able to afford the pursuit of such matters through the courts. It is therefore a matter for courts to consider when awarding costs. Now, I quote Justice Anderson from the Gaskin case, where he said, it appears, and I quote, it appears that the appellant has acted as a public-spirited citizen, zealous for compliance with constitutional and statutory principles and provisions protecting the environment. The arguments summoned, although not ultimately successful, served a very useful function in clarifying an important point in the public law of environmental regulation. The appellant's initiation and carriage of this litigation was therefore entirely consistent with the Escazú Agreement on access to information, public participation, and justice in environmental matters in Latin America and the Caribbean, to which Guyana is a party. The Escazú Agreement aims to provide full public access to environmental information, encourage participation in environmental decision-making, and enable access to legal protection and recourse concerning environmental matters. Accordingly, in the circumstances of the case, the court did not impose costs of losing the appeal upon the appellant, but rather ordered that the parties bore their own costs. I move now to the next point identified, international law. And next slide, Mr. Emmanuel. International law. Environmental rights and protections. Now, prior to the declaration of the United Nations Conference on the Human Environment in 1972, commonly referred to as the Stockholm Declaration, the right to a healthy environment was not something that was a priority for many countries. The indigenous peoples of the region and the world have always advocated that environmental issues are linked to the right to life. The Stockholm Declaration gave us for the first time a formal recognition that, and I quote, man has a fundamental right to freedom, equality, and adequate conditions of life in an environment of equality that permits a life of dignity and well-being, and he bears a solemn responsibility to protect and improve the environment for present and future generations, end of quote. In the decades since the Stockholm Declaration, the right to a healthy environment has expanded throughout the world, with a majority of countries recognizing it as a part of international law. More than 130 nations across Europe, Asia, Africa, the Americas, the Caribbean, and the Middle East have ratified regional human rights agreements recognizing the right to a healthy environment. Decisions on this right have been issued by the Inter-American Commission on Human Rights, the Inter-American Court of Human Rights, the African Commission on Human and People's Rights, the European Court of Human Rights, and the European Committee on Social Rights. Whilst this has been happening across larger regions, the reality is that there are many persons around the world who are not even aware that these international institutions exist, and in many instances are unable to access them for one reason or another. These institutions are critical to drive the movement of environmental awareness, change in behavior, and to empower everyone when it comes to environmental rights and protection. It is absolutely essential that the public be informed and educated on these opportunities and to seek recourse and justice in environmental matters. A reality that we all have to confront is that most breaches occur at a state or local level, and it is indeed at this level that protections are most relevant and impactful. Within states, the Constitution is the supreme law of the land. All other laws must be consistent with it or run the risk of being struck down as unconstitutional and illegal. Rights that are enshrined in a nation's constitution are very sacrosanct, and we heard about that from Justice Anderson in the Gaskin case. Indeed, there are many nations of the world that have moved to incorporating rights to a healthy environment into its constitutions. Today, more than 150 of the 193 members of the United Nations have included explicit references to environmental rights in their constitutions. Now, in the Caribbean, countries such as Guyana, Jamaica, and Belize have incorporated these rights into their constitutions. I've referred to the Guyanese instance, the Guyanese scenario, and in particular, Article 149J of the Guyanese Constitution. And that comes under the protection of fundamental rights and freedoms section of the Constitution. And I'll repeat it so that for the sake of clarity and to reinforce and reiterate. In the Guyana instance, the Article 149J1 provides, everyone has the right to an environment that is not harmful to his or her health or well-being. 2, The state shall protect the environment for the benefit of present and future generations, through reasonable legislative and other measures designed to A, prevent pollution and ecological degradation, B, promote conservation, and C, secure sustainable development and use of natural resources while promoting justifiable economic and social development. Now, in Jamaica's case, Jamaica's constitution was amended in 2012 and provides in its Article 13.3.1 under Chapter 3 and under the Charter of Fundamental Rights and Freedoms, it provides the right, and I quote, the right to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of the ecological heritage, end of quote. In the case of Belize, the constitutional provision seems to be more about allowing the state to take possession of property for protection of the environment. Article 17.2M, 1 and 2 of the Constitution provides, and I quote, nothing in this section shall invalidate any law by reason only that it provides for the taking possession of any property or the acquisition of any interest or right over property, for so long as may be necessary for the purpose of an examination, investigation, trial, inquiry, or in the case of land, the carrying out on the land of work of soil conservation or the conservation of other natural resources, of agricultural development or improvement, which the owner occupier of the land has been required and has without reasonable and lawful excuse refused or failed to carry out. Now, interestingly, the Turks and Caicos Islands Constitutional Order 2011 also makes provision for the protection of the environment. And Article 18 provides as follows. 1, and I quote here now, the legislature and the government shall in all their decisions have due regard to the need to foster and protect an environment that is not harmful to the health or well-being of present and the future generations, while promoting justifiable economic and social development. 2, to this end, the legislature and the government should adopt reasonable legislative and other measures to protect the built heritage, the wildlife, and the land and sea biodiversity of the islands that A, limit pollution and ecological degradation, B, promote conservation and biodiversity, and C, secure ecologically sustainable development and use of natural resources, end of quote. Now, it is also useful, in my view, to look at some decisions from various courts that have interpreted the right to life as incorporating within it the right to a healthy environment. Now, the Constitution of India does not explicitly recognize the right to a healthy environment, but there are many judgments that have been delivered by India's Supreme Court that are worth mentioning. Now, in the case of Subhash Kumar against the state of Bihar, the Indian Supreme Court clarified the state of law in India, ruling that, and I quote, the right to live is a fundamental right under Article 21 of the Constitution, and it includes the right to enjoyment of pollution-free water and air for full enjoyment of life. If anything endangers or impairs that quality in derogation of laws, a citizen has the right to have recourse to Article 32 of the Constitution for removing the pollution of water or air, which may be detrimental to the quality of life. Article 32 of the Constitution of India provides remedies for the enforcement of rights conferred by the part on fundamental rights. The right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental rights conferred is guaranteed under Article 32 of the Constitution. In the case of Virender Gaur against the state of Haryana, the Supreme Court of India expanded upon its articulation of the right, stating that the right to life, and I quote, encompasses within its ambit the protection and preservation of the environment ecological balance, freedom from pollution of air and water, and sanitation, without which life cannot be enjoyed. End of quote. It is also very interesting to note the words of the Constitutional Court in Colombia. In the case of Antonio Mauricio Monroy Cepeda, the Constitutional Court stated, and I quote, "Side by side with fundamental rights such as liberty, equality, and necessary conditions for people's life, there is the right to the environment. The right to a healthy environment cannot be separated from the life and health of human beings." The challenge for us in the Caribbean region and in our region is one that requires us to balance our economic progress with environmental protection and greater environmental rights for our region's citizens and residents. We must, as a region, however, recognize that our continued success depends on us protecting and preserving the environment. We cannot hope to be successful if we are to live in an environment that will not sustain a healthy life. The time may be now for the judicial arm of the state to give greater consideration for the protection of the environment. Further, the impacts of climate change on the natural environment, global temperatures, flooding, ecosystem functioning, river flow, and in terms of agriculture, land productivity, species loss, economic, and in case of economic tourism, natural disasters, loss of lives, and increase in health costs due to asthma, malaria, cancer, and other diseases, provide sufficient rationale for judges and judiciaries to take this important step. Undeniably, we must accept that climate change affects each human being worldwide, and that each country has a sacred responsibility to protect every living being by protecting the water that we drink, the air that we breathe, and judges must act in a manner that is consistent with and gives effect to this. As Ansi Serwer said, and I quote, "Economic growth and environmental protection are not at odds. They are opposite sides of the same coin if you are looking at longer-term prosperity." End of quote. Now, I'm moving now to some recent developments, the cases at the national level. Not yet, Mr. Emmanuel. It is particularly heartening to see, in my view, that states in our region are challenging the status quo. It is very important that this trend continues, recognizing that much of what we are facing and yet to face through climate change was not caused by us. In May 2024, the International Tribunal for the Law of the Sea, in a request for an advisory opinion submitted by the Commission of Small Island States, COSIS, on climate change and international law, found, among other things, that 1, under Article 194 of the Law of the Sea, Paragraph 1, state parties to the convention have the specific obligations to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions, and to endeavor to harmonize their policies in this connection. 2, the obligations under 1, which I just referred to, is one of due diligence. The standard of due diligence is stringent, given the high risks of serious and irreversible harm to the marine environment from such emissions. However, implementation may vary according to states' capabilities and available resources. 3, state parties have the specific obligation to assist developing states, in particular vulnerable developing states, in their efforts to address marine pollution from anthropogenic greenhouse gas emissions. And the assistance can take many forms, and it includes the form of capacity building, scientific expertise, technology transfer, and others, including preferential treatment in funding, technical assistance, and pertinent specialized services from international organizations. Now, further, on the 29th of March 2023, the United Nations General Assembly adopted a resolution co-sponsored by Barbados, requesting that the International Court of Justice give an advisory opinion on the obligations of states under international law in respect of climate change. Barbados submitted its written statement to the ICJ on the 22nd of March 2024. In that case, 83 states have submitted either individually or collectively statements. 12 international organizations have also submitted statements, including the Pacific Islands Forum, the Alliance of Small Island States, the Organization of African, Caribbean, and Pacific States, the Commission of Small Island States on Climate Changes and International Law. In that matter, the states had until the 15th of August 2024 to submit written comments on the statements made by other states and international organizations. Public hearings are scheduled to commence on 2nd December 2024. Although a decision has not yet been delivered because the matter hasn't been fully heard and ventilated, it is certainly a positive development which signals that the region is alive to challenge and one which we should continue to pay attention to. Now, yet further, on the 9th of January 2023, the Republic of Colombia and the Republic of Chile submitted a request for an advisory opinion to the Inter-American Court of Human Rights on the climate emergency and human rights obligations of states under international law in respect of climate change. The Republic of Colombia and the Republic of Chile noted that the climate emergency has, and I quote, a differentiated and devastating impact in certain geographical regions and certain vulnerable groups, end of quote. One of the questions posed, bearing in mind that the climate crisis has a greater impact. One of the questions posed, bearing in mind that the climate crisis has a greater impact on some regions and populations, including Caribbean countries and territories, as well as on the coastal areas and islands of our region and its inhabitants, is how should interstate cooperation obligations be interpreted, and what obligations and principles should guide state actions in order to ensure that the right to life and survival of the most affected regions and populations in different countries and in the region. I think I want to read that again, sorry. One of the questions posed, bearing in mind that the climate crisis has a greater impact on some regions and populations, including Caribbean countries and territories, as well as on the coastal areas and islands of our region and their inhabitants, is how should interstate cooperation obligations be interpreted, and what obligations and principles should guide state actions in order to ensure the right to life and survival of the most affected regions and populations in the different countries and in the region. Again, it's an interesting question that has been posed, and we should all be aware and alert to the decision of the Inter-American Court of Human Rights when it is given. In another case, residents of the Dutch Caribbean island of Bonaire have taken the Netherlands to court for not doing enough to protect them from climate change. That case demands that the government, one, take concrete measures to protect Bonaire from the consequences of climate change. Two, steps up its plans to cut greenhouse gas emissions, contributing its fair share to keeping global warming below 1.5 degrees Celsius by reaching net zero 10 years earlier than the current target of 2050. The formal legal challenge was filed alongside Greenpeace Netherlands in The Hague. Again, although the decisions in these matters are yet to be delivered, it signals that the region is taking up the mantle of seeking justice in climate litigation matters. While these matters are being pursued before international tribunals, judges and judiciaries have to be fully cognizant of these developments and the outcomes of these matters. Although these decisions may not be binding on judges and judiciaries in the region, unless the treaties have been incorporated into domestic law, they must yet be factored into the minds of the courts. Next slide, Mr. Emmanuel, please. Now I move to what is referred to as specialist environmental courts, and that have been set up in various places, in various jurisdictions across the world. Specialist environmental courts. Globally, there has been a movement towards the establishment of specialist environmental courts and tribunals, which is being driven by a number of factors. And these include: one, the development of new international and national environmental laws and principles. Two, the recognition of the linkage between human rights and environmental protection. Three, climate change. And four, public dissatisfaction with existing general judicial fora. Now, the establishment of these specialist environmental courts is a strategy that is also being used by states to meet the United Nations 2030 Agenda for Sustainable Development Goals, and in particular, Sustainable Development Goal 16, which promotes societies that value and seek to achieve sustainable development, provision of access to justice, and building effective, accountable, and inclusive institutions as a means of facilitating same. The 17 Sustainable Development Goals were adopted at the United Nations Sustainable Development Summit in 2015. Principle 10 of the 1992 Rio Declaration on Environment and Development identifies 3 key pillars of sound environmental governance, and they are access to information, access to public participation, and access to justice, as does the Escazú Agreement. The access rights have emerged to be very important in promoting transparent, inclusive, and accountable environmental governance. Access to justice is the foundation of the access rights, as it facilitates the public's ability to enforce their right to participate, be informed, and to hold both regulators and polluters accountable for environmental harm. The building of effective, accountable, and inclusive institutions straddles all 3 branches of government. Judicial institutions are therefore a key aspect and has a key role to perform in giving life to the other 2 limbs of Sustainable Development Goal 16, namely sustainable development and access to justice. Gordon Walker, in his book Environmental Justice, Concepts, Evidence, and Politics, has stated that environmental justice involves at least 3 types of justice: distributive justice, procedural justice, and recognition justice. According to him, distributive justice is concerned with the distribution of environmental goods or benefits and environmental bads or burdens. Environmental benefits include clean air, water and land, green space and biological diversity, and a healthy ecology. Environmental burdens include polluted air, water and land, and loss of green space, biological diversity, and ecological integrity. Distributive justice, on the other hand, involves substantive justice, in that it is concerned with the environmental benefits and burdens that are received by the members of the community. Procedural justice, according to him, includes access to environmental information, entitlement of members of the public to participate in environmental decision-making, and access of members of the public to courts and tribunals to challenge decisions made or the denial of the procedural rights. Recognition justice allows for the inclusion of all groups and communities in the social and political realms with respect to law and governance, including as well environmental decision-making. Warnock, in his book Environmental Courts and Tribunals, Powers, Integrity, and the Search for Legitimacy, identifies 4 components of responsive environmental adjudication. According to him, the first is identifying the distinct characteristics of environmental problems. The second is acknowledging the impact that those characteristics have on the law and dispute resolution, and the challenges they create for adjudication. The third is developing environmental law doctrine, procedure, and remedies that respond to those challenges. The fourth is identifying and implementing particular adjudicative forms and functions to facilitate this process. This includes, according to him, establishing courts with particular constitutions, competences, and expertise that are better able to respond and resolve environmental problems. These take the form of specialist environmental courts. Specialist environmental courts may develop environmental jurisprudence better than other courts. Specialist environmental courts are constituted with competencies and expertise in understanding and adjudicating environmental disputes, which better enable them to develop environmental jurisprudence. Specialist environmental courts are constructed in a way that give greater flexibility to persons and groups to bring matters. The requirements to determine standings are more relaxed. Public interest litigation, therefore, get past the threshold requirements for standing much easier. Sachs, in his book, Defending the Environment, a Handbook for Citizen Action, has argued that public interest litigation helps realize a truly democratic process. Citizen action in the courts can force a reluctant or prevaricating executive to make decisions and to make them in accordance with the law. The availability of the courts means that access to the executive and securing government accountability can be a reality for the ordinary citizen. Citizen actions in the courts can also facilitate citizen access to the legislature, bringing important matters to legislative attention, to force them upon the agendas of reluctant and busy representatives. By restraining conduct of the government or industry that causes or threatens environmental harm, courts can thrust upon those interests with the best access to the legislature the burden of obtaining legislative action. Sachs's insight as to how litigation can be a form of political mobilization and realize a truly democratic process help explain how courts can deliver environmental justice, particularly procedural and recognition justice. By bringing citizen actions in the courts, people, groups, and communities who are alienated and marginalized by government and industry are able to have their interests taken into account by government and industry and to secure the accountability of government and industry. Now, as I'm wrapping up, I want to just quickly make reference to the Environmental Commission of Trinidad and Tobago and the importance of the Environmental Commission to the judicial landscape of Trinidad and Tobago. And the Environmental Commission is an example of a specialist environmental court. Now, as a signatory to the United Nations 2030 Agenda for Sustainable Development, Trinidad and Tobago has aligned its national policies with SDGs, with the Sustainable Development Goals rather, including Sustainable Development Goal 16 in its National Vision 2030. Vision 2030 sets out 5 developmental themes for special focus over the period, including 1, placing the environment at the center of social and economic development, which envisions the strengthening of environmental governance and management systems as a short-term goal. 2, delivering good governance and service excellence, and this involves the institution of modern legal regulatory system of justice, including environmental justice as short-term goal. The Environmental Commission of Trinidad and Tobago is integral to the legal regulatory system of environmental justice, since it provides the forum for hearing environmental disputes under the Environmental Management Act, Chapter 3505 of the Laws of the Republic of Trinidad and Tobago, and enforcing many aspects of the said Environmental Management Act, regulations and standards, and in strengthening environmental governance as well. The Environmental Commission is a specialist court and a superior court of record established by the legislature under Section 81 of the Act, that's the Environmental Management Act, as part of the state's commitment to the development of a national strategy for sustainable development. It is a court very much like the court that Warnock spoke to and which I referenced above. Now, the jurisdiction of the Environmental Commission can be divided into 3 broad categories, and they are the types, I'll go by the types of matters: applications, appeals, and decisions. So the jurisdiction of the Environmental Commission pursuant to the Environmental Management Act can be divided into three broad types of actions, which are broad applications, appeals from decisions, and direct private party actions. Now, the various types of applications that are brought would be applications to hear and determine requests for a deferment of a decision of the Environmental Management Authority to designate an area as an environmentally sensitive area or a species as an environmentally sensitive species. Another type of applications that can be brought and that are brought is to hear and determine requests made by the Environmental Management Authority for injunctive reliefs or restraining orders to prohibit the continued violation of an environmental requirement identified under the Act or prevent the activity which leads to the violation. Another example is applications to hear and determine requests for civil assessments of the quantum of damages that is to be compensated to the state for damage and loss incurred as a result of the violation of an environmental requirement. And lastly, to hear and determine requests, applications to hear and determine requests by the Environmental Management Authority for enforcement of consent agreements. And those are agreements that contain, among other things, admissions of a breach by a party of an environmental requirement and an agreement to rectify the breach and to pay the necessary compensation to the state. Now, there are various appeals that can come before the Environmental Commission, and these include appeals challenging the decisions or actions of the Environmental Management Authority. Persons may challenge the Environmental Management Authority's findings, decisions, and actions by appealing to the Environmental Commission. Generally, they can also challenge decisions of the Environmental Management Authority to refuse to grant what is referred to in the Act as Certificate of Environmental Clearances, which are clearances to undertake certain activities, or from conditions imposed on those certificates of environmental clearances. They can also appeal challenging the designations of areas as environmentally sensitive areas or species as environmentally sensitive species. They can appeal as well challenging any determination by the Environmental Management Authority to disclose information or materials claimed as a trade secret or confidential business information in documents that they submit before the Environmental Commission and which the Environmental Commission seeks to disclose to the public. And lastly, they can appeal challenging, any interested person can appeal challenging on the ground that the Environmental Management Authority has failed to comply with the requirement for public participation under Section 28 of the Environmental Management Act. And one unique form of action that is included in the Environmental Management Act, and which the Environmental Commission of Trinidad and Tobago has jurisdiction to hear, is what is referred to as direct private party actions. And these are actions that are brought to hear and determine complaints, or these are actions that are brought by private persons against another private person, so being brought by an applicant against a respondent, on the basis that the respondent has violated any of the environmental requirements that are specified in the Environmental Management Act. It is the only type of action before the Environmental Commission that does not immediately involve the appearance of the Environmental Management Authority as a party, since it involves one private individual bringing an action against another individual or organization. Now, Trinidad and Tobago is in the very unique place as being the only country in the region to have such a specialist environmental court in its judicial landscape, offering to persons access and an avenue for environmental justice in matters affecting the environment. The Environmental Commission, as part of the system of superior courts in Trinidad and Tobago, is an essential part of the governance structure and will advances the agenda of environmental governance. The Environmental Commission is therefore, to borrow the words of the late Klaus Topfer, a crucial partner in promoting environmental governance, upholding the rule of law, and in ensuring a fair balance between environmental, social, and developmental considerations through its judgments and declarations. Now, very quickly, I just want to touch on the Escazú Agreement. It was mentioned in a number of the decisions that I referred to above. And like you would have gleaned, the objective of the Escazú Agreement which is set out in Article 1, is to guarantee the full and effective implementation in Latin America and the Caribbean of the rights of access to environmental decision-making and access to justice in environmental matters, and the creation and strengthening of capacities and cooperation contributing to the protection of the right of every person of present and future generations to live in a healthy environment and to sustainable development. In a nutshell, the Escazú Agreement is very often referred to as an agreement, or very often referred to as the agreement on access to information, public participation, and justice in environmental matters. Next slide, Mr. Emmanuel. Thank you. Delivery of environmental justice. As I close, the processes and outcomes of dispute resolution have a quality and authority that go beyond the function of resolution of disputes. I want to repeat that. The processes and outcomes of dispute resolution have a quality and authority that go beyond the function of resolution of disputes. As Fisher, Lange, and Scottford in their book Environmental Law, Text, Cases, and Materials observe, and I quote, "Courts are more than the sum of their parts, and the judgment of a court has a symbolism and authority that few other documents have. The judgment is an icon of the rule of law, and a particular case is a carefully orchestrated process through which indeterminate aggregations of persons, words, stories, and materials are transformed into facts, intention, causality, responsibility, and property. Law in the form of a judgment has a homeostatic quality in which any argument must be integrated into the integrity of the legal edifice. The processes of courts are thus fundamental both to the construction of the legal discourse and to the authority of the law itself." End of quote. In conclusion, I would like to reiterate that environmental justice is not merely an issue of resource allocation, but one of fundamental human rights and equity. The disproportionate impact of environmental degradation on marginalized communities underscores the urgent need for systematic change within our judicial and legal systems. This change begins with educating ourselves as judges and judiciaries on environmental issues and their impacts on human rights. Addressing these inequities require a comprehensive approach that includes robust policy, law reforms, inclusive decision-making, and community empowerment. Governments, corporations, civil society must work collaboratively to ensure that all people, regardless of race, income, or geography, have access to clean air, water, and land. The pursuit of environmental justice is integral to creating a sustainable future where the benefits of environmental protection and restoration are equitably shared. By championing these efforts, we move closer to a world that respects both the planet and its people, fostering resilience, justice, and long-term environmental health for all. My last statement is a call for further action and collaboration in addressing environmental justice. We are the ones to make it happen. I trust that you would find my presentation useful and there would be something in it for you to take away and apply going forward. I wish all of you a very successful conference and continued success in the future. Thank you. Next slide, yeah. Thank you very much.
Thank you very much, Your Honor, for that very informative presentation and the depth of case law and jurisprudence that you've presented to us. I now open the floor for questions. Feel free to ask questions by turning on your mic or your cams or by typing it in the chat. Your Honor, I have a question arising out of the Mussington case.
Sure, Mr. Emmanuel.
Have you seen instances where persons with other grievances use an environmental concern as a sort of a mask to advance that claim? And since Mussington, with the sufficient interest tests seeming to be broader, have you seen instances of that where there may not be a genuine environmental concern, but they use it to advance protection of any other grievance they may have? For example, if there is a compulsory acquisition decision that it may not have liked, if they can find some environmental issue to link it to.
I haven't seen it, but I know our courts and our judges are more than qualified and experienced to know when parties are when their motives are not genuine and when their bona fides are not genuine to address it so that I am not fearful. I haven't seen it and I'm not fearful that the courts will I am very confident, rather, let me put it this way, that the courts are well equipped to treat with those instances. So I don't think it's going to lead to an abuse. I think I look at it on the positive side. I think the environment requires a voice. There are many aspects of the environment that if you don't allow it to be brought forward, environmental protection, environmental issues can remain idle, can remain unattended, and all of us are worse off for it. So I look at it from the positive side, and I think there's a lot of benefit and positive to come from a broader interpretation of the issue of standing.
Great, thank you very much.
And if there are any questions even after, I mean, I'll be more than happy to address them as best as I can. I mean, I hope I didn't bore everybody into an afternoon nap. I mean, at this time of the day.
I would say certainly not. For me, it was very interesting, Your Honor.
But I do think the environment is one that requires, greater attention by the judiciary, by in our region, so as to ensure that adequate protections are afforded, to ensure that the problems that many times laws are designed to protect are addressed, and ultimately it will redound to the benefit of the citizenry of the region, of the citizens of the countries. And like we all know, climate change is real. The negative impacts of climate change, the damage to the environment is not easily repaired, and it's not repaired in short order. And the environment includes not just land and water and air, but biodiversity, plants, animals, I mean, there's so many there. It's so broad and it's so all-encompassing that you really need to give it the attention that it deserves, and so as to ensure that the protections that are afforded by constitutions and laws are able, the environment is able to benefit from it, and we, by extension, benefit from those instances.
Thank you very much, Your Honor. So if there are no further questions, I'd like to say thank you, and I'd like to hand this over to Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, for a formal vote of thanks. So, Ms. Carter.
Thank you.
Good afternoon, everyone, and good afternoon to Your Honor, Mr. Sunil Sookraj.
Good afternoon.
Thank you for your presentation, which has given us quite a lot to consider, from the references to the various case laws to the various treaties. You have no doubt enriched our understanding of environmental law issues. No doubt as well, our perception of environmental law issues has changed in light of your presentation, and we must now all take a firm decision to do better for our environment, understanding, as you would have quoted through the Stockholm Declaration, that we have a solemn responsibility, I believe, to protect and improve the environment, not just for this present generation, but for future generations as well. and further that we all have a right to a healthy environment. So with that being said, it is hoped that in light of your presentation that we all take a greater interest in environmental issues. And we once again thank you for what was a very informative and thorough presentation.
Thank you very much. Thank you.
You're welcome. I now hand you back over to Mr. Emmanuel to close off today's session.
Thank you very much, Ms. Carter. All right, so that brings this afternoon session to a close. We thank everyone for participating in day one of JEI Week 2024. We hope you will join us tomorrow, where we would delve into the topic of anti-money laundering. I would like to ask everyone to also please feel free to join our website, jei.tc, where you can find all the links and all the programs for this JEI Week seminar. And very shortly, the recordings for this week will be available. So thank you very much, and we look forward to your continued participation in JEI Week 2024. Good afternoon, everyone.
Thank you.
Thank you all.
You're welcome.